If you're litigating a DVPA case where the alleged abuse is against a child and the child isn't going to testify, this published opinion matters because the Court of Appeal just confirmed a pathway for admitting the child's out-of-court statements for their truth with safeguards. And there's a second lesson in this case. Don't let language barriers quietly shrink supervised visitation. This case reversed a once-a-month order for exactly that reason. I'm Ron Funk with the California Family Law Appellate Group. Today's case is out of the 4th District, Division 3, and it's significant because it clarifies how courts can evaluate hearsay statements of a minor in a DVPA proceeding alleging sexual abuse without pretending the hearsay problem doesn't exist. Here's the setup. In a dissolution case, the wife sought a DVPA restraining order. The core allegation was the sexual abuse of an older child, KR, who was 13. The child did not testify at the DVRO hearing. Instead, wife testified and relayed the child's statements to the court. The trial court issued the DVRO, and as to the younger child, SR, who was age 4, it ordered professionally monitored visitation, but limited it to once a month because the court was concerned the monitor wouldn't understand Spanish communications. The published point is direct. The Court of Appeal says the child's statements were admissible for their truth under the child dependency hearsay exception framework from In Re Cindy L. And it publishes the opinion to make clear that this applies when a DVPA restraining order is sought based on sexual abuse of a minor. Now, this matters because trial courts sometimes try to sidestep hearsay by saying, I'm not admitting it for truth, I'm admitting it for the state of mind. The Court of Appeal calls that out. If the whole reason the statement matters is whether abuse occurred, state of mind isn't a real solution because it's not relevant unless the court is actually relying on the statement as true. Then the court says something important. It is not creating a new hearsay exception. It is simply applying an existing exception to a comparable courtroom setting where there is a substantial need for this class of evidence, as long as the evidence is otherwise reliable. So, what are the safeguards? The court adopts the Supreme Court's 3 prerequisites from Cindy L. and says they apply equally here. 1, the time, content, and circumstances show sufficient indicia of reliability. 2, the child is available for cross-examination or there is corroboration. And 3, the opposing party had adequate notice the statements would be introduced. On the facts here, the court found those prerequisites were satisfied. Now, a crucial clarification, because it's easy for this issue to sneak in. The trial court looked at criminal allegations pending against husband and treated them as substantive proof of abuse. The Court of Appeal says no. Under Family Code Section 6306, the court cannot consider information from the search that does not involve a conviction. So the takeaway is not that criminal history is irrelevant. It's that pending allegations, standing alone, cannot become your substitute proof of DVPA abuse through a 6306 search. The DVRO was still affirmed because the evidentiary error was not prejudicial on this record. Now the part you don't want to ignore. The court reversed the once-a-month visitation limitation. Here's why. The trial court's sole stated reason was concern that the professional monitor would not understand communications in Spanish between the father and child. But Family Code Section 3200.5 says a professional monitor must be able to speak the language of the supervised party and the child, or provide a neutral interpreter over 18 who can do so. So the Court of Appeal held the visitation decision was influenced by an erroneous understanding of the law, meaning the court didn't properly exercise its discretion, and it remanded for the trial court to re-exercise discretion on visitation. It's noteworthy the court reversed this rather than calling this error harmless. That's not typical in visitation appeals where discretion often swallows the error. The takeaway isn't that monthly visitation is always illegal, but that monthly visitation is the kind of restriction that demands a real, legally correct justification. And here's the practical question. Can you use this to argue for weekly time? Not as a per se rule. This opinion doesn't say weekly is required, but it does give you a persuasive framework. When a parent's contact is being reduced to an extreme minimum, the court can't just gesture at discretion. It has to articulate why a more regular schedule, weekly or otherwise, is not in the child's best interest. And it has to do so based on a correct legal premise and evidence. So, with the right record, you can cite this case to push the conversation from is monthly allowed to what is the least restrictive schedule that still protects the child, and why isn't a more typical cadence like weekly workable here? Here's 3 practice pointers for trial counsel. First, build. If you're relying on a child's out-of-court statements in a DVPA sexual abuse case, build the record around the 3 Cindy L. prerequisites: reliability, cross-examination or corroboration, and notice, because that's the gate the Court of Appeal is using. Second, separate. If a court references a 6306 criminal history search, separate convictions from allegations. Pending allegations can't be used as substantive proof of DVPA abuse through that mechanism. Third, define. If supervised visitation is being ordered through a professional monitor, put the language issue on the record the right way. The statute requires language capability or a neutral interpreter, so it shouldn't be the reason visitation frequency gets compressed without analysis. That sentence is the headline. If you're a trial lawyer and you want a fast appellate lens consult to stress test issues like this, especially evidentiary foundations and clean legal error preservation, you can reach me at cflappellategroup@gmail.com. And the standard reminder, this video is for education only. It's not legal advice, and it doesn't create an attorney-client privilege. So I'll see you later when the next case drops.